seats. Chair recognizes a quorum. Members, today we have 4 bills on the agenda. First is HF 6, wage theft. HF 554, Chair Moran. And then we have 2 Scott bills. That may not come in that order, but first we're going to do wage theft. Representative Mahoney, as he's making his way up, can I have a motion to approve the minutes of March 4th?
So moved.
Representative Zhang and Noor move the minutes of March 4th. Any discussion? All in favor say aye. Aye. All opposed say no. Motion passes. Minutes of March 4th are approved. Representative Mahoney, welcome to the committee. Please, well, I will move Representative Mahoney's bill, HF6, be recommended to be re-referred to Ways and Means Committee. And we have an amendment, the A13 amendment.
That is correct, Mr. Chair.
Representative Zhang, will you offer the A13 amendment? Whoa. Then the A13 amendment is before us. Any discussion? All in favor say aye. Aye. All opposed say no. Motion passes. The A13 amendment has been adopted. Representative Mahoney, tell us about the bill as amended.
Mr. Chair, this is the second stop on this bill's journey. It had a couple of requests and recommendations from the Labor Committee. That is the much of the A13 amendment. Would you like me to go through the A13 amendment or?
Well, we've already adopted it, so just go through the whole bill together, Chair Mahoney.
Okay.
Unless you want to.
No, Mr. Chair.
Okay.
This bill is in your committee because there were some complaints about intent. So we put in the A6, the A13 amendment adds in the 609 to make it criminal. If we're not going to keep some of the language from the administrative penalties, we took those out. And we put the criminal code into this particular amendment. And it is now in the bill itself, which creates a gross misdemeanor at $500 worth of wage theft and a felony at $1,000 worth of wage theft. And then it has some language in there to make an egregious penalty if it's an egregious amount, which starts at $35,000. I can't remember the exact language. I can certainly look it up. The egregious means imprisonment for not more than 20 years or payment of a fine not more than $100,000 or both. And if the dollar figure hits $35,000. This bill in itself is not trying to punish small businesses that make a mistake. We've got it all over in here where the administrative penalties instruct the Commissioner of Department of Labor and Industry to use discretion in the size and the intent and the egregiousness of the offense in determining the punishment or the fine. This bill now allows for the department to get, in law, to get all of the dollars back from someone who's had their money stolen by wage theft. And then again, when we moved it over to 609, the last couple of pages, where does that go in? That is on the, I think it's on page 12, yes, line 15, where it draws in to the 609 and bringing in the ability for the not only just the department to chase after these type people, but the Attorney General and county attorneys. I have 4 testifiers, Mr. Chair. How much time do you?
Bring them up.
Bring them up.
Mahoney.
Well, where is my list?
Got County Attorney Freeman, Commissioner Lepping, Adam Hansen, and Lauren Schauthorst.
Let's bring up Mr. Freeman.
All right. Welcome to the committee. Welcome back to the committee, County Attorney Freeman.
Thank you, Mr. Chairman. Members, it's nice to be back, although I've got to acknowledge it's nicer in short doses or small doses than it was every night, all night. My chief mentor in the Minnesota Senate, Gene Merriam, didn't really begin to think until after midnight. And he's the reason you all now have the midnight rule, which makes a lot of sense for us people who need a little sleep at night. But Mr. Chairman and members, I'm pleased to be here as the Hennepin County Attorney in support of the wage theft bill. As the head of the Hennepin County Attorney's Office, we have charged the only case that I'm aware of in labor trafficking in the recent past. And labor trafficking cases inevitably have wage theft components in it. Passage of this bill will give us a much better tool to use to stop this egregious conduct. I'm speaking on behalf of myself, and I know that my sisters and brothers in the Minnesota AFL-CIO, especially the carpenters and SCIU, support this effort. This bill adds to Minnesota statutes and gives us additional tools to go after those who steal hard-earned wages. The new subpart to the theft statutes makes punishment under the existing sentences portion for theft as follows. Misdemeanor is for thefts of under $500, gross misdemeanor $500 to $1,000, and for a felony $1,000. And it also makes employers guilty of gross misdemeanors if wage theft occurs as a result of retaliation for asserting their rights under the wage theft statute. Why is this important? Wage theft is not just a tortious conduct, it is criminal. Conventional wisdom suggests that this is civil in nature, but the behavior is certainly criminal in nature as its pernicious effects cause workers to live in squalid conditions and subject to unsafe working conditions. These workers are kept off the books, often not provided work comp support, and are forced to work in the shadows. The theft of deportation is often used against some of these undocumented workers. This causes immense harms not only to the employees, but to the communities in which they live and those who have come to depend on their work. Unscrupulous employers have devised exploitive and profitable schemes that cannot be trusted to work things out with their employees. Let me say here that I'm only talking about those rare employers who abuse these workers, such as the employer that I charged in the previous case, which I'm not at liberty to talk extensively about because it's pending. Secondly, this statute will help us fight human trafficking. Wage theft is almost always present when humans are being trafficked. The Advocates for Human Rights recently completed a study on labor trafficking and found a deep and inherent connection between labor trafficking and wage theft. Criminalizing this behavior helps fight human trafficking. Thirdly, it provides equal treatment between employers and employees. Currently, if an employee steals from an employer, a server stealing cash from the till, or a construction worker stealing materials, for example, they can easily be prosecuted, and frankly, they are under our current theft statute. It is much harder to prosecute an employer, however, if they're engaging in wage theft. By specifically including wage theft in the theft statute, employers will now be held to the same standard as employees. Theft is theft. What's good for the goose is good for the gander. Why am I here? Because we are finding that wage theft and labor trafficking is increasing profoundly. And we find that in the construction trade, and frankly, we find it elsewhere. Minnesota is a state of hardworking immigrants. My great-grandparents came here to work hard in the lumber mills and were not cheated out of their wages because there was a strong group of employees that would not let that happen. As I listen to the stories from my grandparents' generations and read about the immigrants working here and looking at the cases that have come to my office, I understand why this statute's important. You know, this legislature protected workers' rights going back 50, 75, 100 years ago. But we have to amend and add new statutes as new shenanigans are made possible. Members, I support this and commend the legislature for considering it. I'd be glad to answer any reasonable question.
Thank you, Mr. Freeman. Questions for Mr. Freeman? Appreciate it. Thank you for being here, for your testimony.
Thank you.
Next, we have the Dole Commissioner, Ms. Lipping. Welcome to the committee, Commissioner. Please introduce yourself for the record. Begin your
Good
testimony.
morning. I'm Nancy Leppink, and I'm the Commissioner of the Minnesota Department of Labor and Industry. It's a pleasure to be here this morning with you to speak on behalf of this important bill. This is the first time I've had the opportunity to testify on behalf of this legislation, which I believe goes to the core of our American ethos. In America, in Minnesota, if you work hard, if you play by the rules, you can achieve the American dream. That's what we believe as Americans. We can raise a family, we can own a home, we can educate our children, we can start a business, and even put enough away for retirement. And I'm certain that we all agree that a key tenet of that American ethos to achieving that American dream is if you work hard, you should receive a fair day's pay for that work, and even more basic, if you work hard, you should be paid for that work. And the amount you are paid and when you are paid should comply with the agreement made between you and your employer, and certainly comply with the minimum standards established by law. I know few workers, certainly low-wage workers and even seemingly well-paid workers, who can afford not to be paid for all the hours they work, not to be paid for their overtime, which for many workers is how they make ends meet, not to be paid the legally required or agreed to amount, to have their pay delayed, or worse yet, not to be paid at all. Wage theft is a term that became a rallying cry against these practices more than a decade ago. And its use grew as the misuse of business practices such as subcontracting, outsourcing, insourcing, franchising, and classifying workers as other than employees. Business practices that are today further enabled by technology grew in highly competitive and labor-intensive sectors: janitorial and maintenance services, home care services, security services, call center services, services provided through the platform economy, and in the restaurant and hotel sector, and in the construction sector. These sectors repeatedly come across the desks of my staff in the Department of Labor and Industry, and these sectors are frequently identified in complaints by workers of wage theft. These are sectors where competition is fierce, and reducing labor costs can create a significant competitive advantage. Of course, there are many legal ways to reduce labor costs: improving your business's productivity, stabilizing your workforce, improving the skills of your workers, improving the quality of your services are all significant ones. Frequently achieved through the payment of fair wages, provision of adequate benefits, support of lifelong training, and effectively managing the safety and health of work. But when competitive advantage is achieved through illegal means, it can trigger a race to the bottom. And even as the attorney for Hennepin County, Mr. Freeman, has just stated, even in Minnesota, that bottom includes what is essentially slave labor. And the consequence is those businesses who play by the rules are put out of business by those who don't, and workers lose the good jobs those businesses have created. So we have a decision to make. Are we going to stand by while workers who work hard and play by the rules are denied even a glimpse of the American dream? Are we going to stand by while businesses who work hard and play by the rules, who value their workers, are pillars of their communities, are undercut by those who don't? Or are we going to correct the course? The Walz and Flanagan administration believes that the only decision is to right the course. And key to writing the course are laws that create strong incentives for businesses to comply with fair labor standards, require needed documentation of the terms of employment agreements so that workers and employers are able to protect their interests, ensure agencies responsible for enforcing the laws are able to do their jobs effectively, and engage the very parties, employers, workers, and their organizations, associations, and communities who are in a position to influence compliance and to support the businesses and workers who are playing by the rules. This bill does all four, and the amendment strengthens it further. And the department is strongly committed to working with Representative Mahoney and to ensure that this bill creates the needed foundation to right the course. Thank you.
Thank you for your testimony, Commissioner. Questions for the Commissioner? Representative O'Neill.
Thank you, Mr. Chair. If you could refer to the bill, and I don't know if the amendment changes this, I don't think it does, but on page 1, line 1.17, you're requesting documentation or records from the business in a specific format. Can you explain what you mean by, or what is meant by, what kind of specific format are you requesting and why that's been added to the bill?
Commissioner Lepping.
So the need for records to be in specific format is in order for the department to be able to effectively review what those records, and to evaluate and whether wages have been paid properly, whether they've been calculated properly, whether hours have been properly kept. And so consequently, there's a need primarily for content of what those records would include, but also that they're presented in a way that the department can effectively evaluate and make the determination of whether the wages have been paid in compliance with the law.
Representative O'Neill.
Thank you, Mr. Chair. What specific format are you speaking of?
Commissioner Lepping.
Basically, it would be a format that clearly articulates the worker, the hours that the workers worked, the rate of pay that the worker has been, in their contract or by law is required to be paid, how any deductions from wages, basically the criteria that and the information that the department would need in order to determine whether or not a worker has received the wages that they're obligated to be paid under the law.
So, Commissioner Lepping, essentially, an employer can't be funny and try to submit it in binary code, right? Like trying to pay your water bill on all pennies? Is that the idea?
So the idea is that we're not sending you a template where you have to redo all of your payroll records. What we're saying is that we need certain information from the employer so that we can effectively determine whether or not there is a case for wage theft or not. So.
Mr. Chair.
Representative. Okay.
Thank you, Mr. Chair.
You're welcome.
Then you might want to change the language to, instead of format, content. Because format, to me, I've done payroll, had my own business, and that could be for maybe you want an Excel spreadsheet, maybe you want a QuickBooks report. It could be a plethora of different things. So it's not the format that what you just testified to is not the word format. It's content. So if you're asking for a specific format, that means you want an Excel spreadsheet, you want a PDF, that's format, or a form that you fill out or something like that. But that's not what you just testified to. So if you really mean content, then you probably should change the language to specific content and what that would be, but not the format that content appears on. Thank you.
Well,
Mr. Chair.
I guess, I don't know. Representative O'Neill, I would take exception to that. I think that she does mean format in the sense, like I said, I mean, someone could deliver 48 banker's boxes and you got to sift through them to find the one sheet of paper that they wanted on there. I think format is probably appropriate, but did you want to speak to that, Commissioner?
Mr. Chair, Representative, well, that is the intent, and so consequently, we can certainly discuss with Representative Mahoney if there's a way to make that clearer, but that is the intent of the use of the word format.
Okay.
Mr. Chair.
Representative O'Neill?
Thank you, Mr. Chair. I appreciate the fact that the penny analogy, but I've done books for nonprofits, for businesses, and all of that. I'm just saying, if you're asking for specific content, regardless of how that content comes to you, those are two different things. And format to me means, this is a QuickBooks report in a certain format. This is an Excel spreadsheet in a certain format. But content is different. That could come to you in all kinds of different ways. And I think it needs to be clear so the businesses know what you're asking for. So that's my only point. Thank you.
Thank you, Representative O'Neill. Representative Considine.
Thank you, Chair Lesh. I contacted your office about 18 months ago, and we had a business that changed hands in Mankato, and we had people that had worked there for 20-plus years, and a lot of them had 800, 900, 1,000 hours of sick time. When the new folks came in a couple weeks later, they looked at their pay stub, and everybody had been reduced to 280 hours of sick time. I thought, since this is something they had earned and accumulated, that was safe. I found out it wasn't. Is there something we can do about that?
Commissioner Lepping, and if you want to defer to the Attorney General on that, we have a representative here on that, too.
Mr. Chair, Representative. Actually, I think that that issue is being addressed in the sick and safe leave legislation that's being proposed that has express language in it that deals with the issue of what happens when ownership changes and what are the rights related to sick leave that has accrued. Don't happen to have that bill in front of me, but it is an issue that I think has been identified, and at least in the context of that bill, is they're working to address.
We're hearing that bill next week.
Oh,
so-
okay, well, thank you. Maybe I wait to them, but thanks for answering. I was appalled that thousands of dollars of benefits just disappeared.
Chair Johnson. Okay. Thank you very much for your testimony, Commissioner. Next testifier, we have Carly Moline, representative for the Minnesota Attorney General's office. Welcome back to the committee, former Representative Moline. You sat on this committee once upon a time, I think.
I did, actually, the whole time I was here.
You did a great
It
job.
was a good time.
Welcome back.
Thank you, Mr. Chairman and members. Good morning. For the record, my name is Carly Moline, and I'm here on behalf of the Minnesota Attorney General's office. Attorney General Keith Ellison is in strong support of House File 6, a bill designed to protect Minnesota workers who have not received the wages they've earned. Thank you, Representative Mahoney, for bringing this important bill forward. And thank you to the Department of Labor and Commissioner Lepping for your commitment to protecting workers' rights and wages. Representative Mahoney's bill provides for a comprehensive and collaborative approach to combating wage theft and protecting Minnesota workers. In addition to the strengthened administrative remedies found in the bill, the amendment brought forward by the author, which was adopted by the committee, codifies enforcement and remedies available under the Attorney General's authority. Attorney General Ellison is committed to Minnesotans being able to afford their lives and to live their lives with dignity and respect. In alignment with these values, the Attorney General has made the establishment of a wage and hour division within the Attorney General's office one of his top priorities. Last month, the Attorney General brought in a national expert to assist in the establishment of a wage division within the AG's office. Several states have this model, and in conjunction with their State Department of Labor, have had great success in protecting workers' rights, recouping unpaid wages and benefits, prosecuting the most egregious offenders, and stopping businesses whose entire model is built at the expense of workers through trafficked labor, through misclassification, and by simply not paying employees the wages they've earned. Attorney General Ellison plans to advance a model in Minnesota to provide for a comprehensive approach to combating this issue. House File 6 provides the necessary infrastructure for the state to protect Minnesota workers. On behalf of the Attorney General, thank you for affording me the opportunity today to testify in favor of House File 6.
Thank you, Ms. Moline. Questions for Ms. Moline? Thank you very much. Thanks for your testimony.
Thank you.
Now, we have Jessica Lumen here, State Building Trades Council. Welcome to the committee. Please introduce yourself for the record.
Mr. Chairman, members of the committee, my name is Jessica Lumen. I'm the Executive Director of the Minnesota State Building and Construction Trades Council, and on behalf of the 70,000 construction professionals represented by trade union affiliates, I want to express our support for this bill and our appreciation to the author and the Walz-Flanagan administration for addressing wage theft in Minnesota. We are concerned about wage theft in the construction industry because it exploits the very workers who join our industry to provide for themselves and their families with good, safe jobs. Our contractor employers who comply with the law cannot compete against contractors who do not pay wages, do not pay taxes, and do not care about the future of Minnesota's economy. We recognize the Department of Labor and Industry needs additional resources to investigate and additional authority to adequately enforce laws that protect Minnesota against wage theft. Further, we need strong administrative, civil, and criminal tools to address those contractors that have put wage theft at the core of their business model. This bill provides that protection. The bill as amended today has addressed many of the concerns that have been raised in previous hearings, as well as by many stakeholders. It lowers the potential initial penalty for failure to keep and maintain records. It clarifies the definition of wage theft and makes retaliation a separate violation. It clarifies that an employer can have a pay period of up to 16 days, allowing for the common practice of paying bi-monthly. For your own reference, pay periods are already required to be 15 days in the construction industry under Minnesota law. It maintains an expedited administrative process for smaller wage claims, but it does to remove the presumption of violation that had been discussed in previous hearings. This bill is not about, as the author said, not about honest mistakes or simple errors. We're not advocating for more administrative burden or bookkeeping requirements for employers. We advocate for a responsible approach to this important issue to ensure that compliance with the law is rewarded and that violations are investigated and prosecuted. The Building Trades looks forward to continuing to work with the author, DLI, and stakeholders to ensure that Minnesota has the tools to address wage theft when it happens, but more importantly, to deter employers from ever adopting the business model in the first place. Thank you.
Thank you for your testimony, Ms. Lumen. We have two more pro-testifiers that just, they notified us just before committee and were added. So I would ask them to keep their comments to 2 minutes, which I should have been doing up to this point, actually. Abel Garcia, and Miguel, last name starts with A because I can't read my CA's writing. I'm sorry. Tell us, please introduce yourself.
Good morning. My name is Evo Garcia, so thank you, Mr. Chair of the committee.
Welcome to the committee.
Thank you so much. So just I want to please start to the wage theft now because we need your help taking like action now because there's, I don't know, because we need to stop into the wage action because like therefore the tax fraud affect us community and increase our taxes every year. So let's work it together, stop it with the wage theft and the tax fraud because we need your help now. So yeah, because for us, I mean, I talked for my community, for the Hispanic community, because for us, we have like so many frauds too. I mean, we try to work we try to give it to my, I want to give my workers the best benefits, best, yeah, I want to pay the right things. But how? That's the point. That's why we need you help, guys, for stop this thing because I had a victim for the bin. I the victim for the wage theft. That's the point. I mean, always. So we try to. I mean, we're working so hard, and the end to the project, they don't want to pay us. And then for me, I have my small company. I need to pay my guys because they had a families too, and the more affecting that's me. But it's okay. So that's why I'm here now because for real, guys, I need your help.
And Mr. Chair, if I might,
Chair Mahoney.
to his point, approximately bad contractors have a $34 million advantage over good contractors because they aren't paying state income tax, federal income tax, state excise taxes, contributions to unemployment insurance, Social Security, Medicare. And that's an advantage that a good contractor, a fair and honest contractor, does not have. And that is the point, not only for him, but for many contractors that are trying to bid on good projects and pay fair wages. So thank you. Thank you,
Yeah.
Mr. Garcia.
No,
Thank you,
thank you
Chair
so
Mahoney.
much.
Thank you for coming to the committee.
Thank you.
Miguel Arezzo. Welcome to the committee. Please introduce yourself for the record. On deck, we have Adam Hansen. So if you can just come down and be ready immediately. Please introduce yourself.
Thank you, Mr. Chairman and members of this committee. My name is Miguel Arceo, and I'm owner of Frida Drywall. We are a new company in the union business for 2 years, and I've been working as a labor in the industry for 25 years. So I've been seeing wage theft a lot, and this makes it impossible for us now that we're union to compete in when this wage theft. Please support this bill. We are trying to pay fair wages to our community we are trying to clean the face of our community, and we are trying to make them have the American dream that they want. That they want. So please stop this fraud, wage thief. They affect our communities in a great state of Minnesota. Thank you very much.
Thank you very much for your testimony. Any questions from members? Thank you. Thank you for being here. Mr. Hanson, welcome back to the committee.
Hello again.
Please introduce yourself for the record.
Thank you, Mr. Chair and members. My name is Adam Hansen. I represent the Associated Builders and Contractors of Minnesota. Our contractors and their multi-skilled craft professionals live and work throughout Minnesota. They build your schools, your multifamily housing, your retail, your medical, your industrial facilities, and more throughout your districts. I want to thank Representative Mahoney for acknowledging in previous committee stops that 99% of Minnesota employers do the right thing by their employees. They value their employees, they pay them on time, and they pay them for the amazing work they perform. But what our contractors have concerns about with this bill is the penalization of honest mistakes that can happen in payroll and accounting, especially in our industry, in the construction industry. If an employer intends to underpay and cheat their workers out of what they are owed, we can already penalize them to the fullest extent of the law, and we have no issue with that. It is not uncommon for our contractors' employees to be able to do more than one discrete job classification on a project. For example, if you're installing a door on a multifamily project, you're a carpenter. But if you're hauling that door from another location on a project to where the door is to be installed, you're a laborer. Now, on a prevailing wage project, if a time card is filled out incorrectly, either by that construction worker or a job site foreman, and there's an honest mistake as to the hours worked in each of those discrete labor classifications, the bill would automatically make the employer subject to fines and a dolly citation. Additionally, some of our contractors have multiple offices, multiple locations throughout Minnesota. In construction, unlike many industries, it is uncommon for a construction worker to go to their office or that location on a regular basis. They simply head to their project for the day, then return home. Line 2.3 of the original bill, not as amended, creates an ambiguity about keeping those records for that employee. Where does an employer keep the payroll records and other records required under this bill if they have multiple offices? Which employees' records do they keep at which location? Getting either of those questions wrong under this bill can land an employer a fine of up to $10,000, even if it is an honest mistake. We also have concerns with language in the amendment that removes the intent requirement for a misdemeanor under this bill. Also, when a contractor wants to give a raise or give a bonus to one of their employees, the employee would not be able to receive that benefit, that new raise, that new bonus, unless and until the employee signs a card, a notification of the new wage or benefit, and then he or she must wait 7 days before they can receive that new increase. We do want to thank Representative Mahoney for removing with this amendment the guilty until proven innocent regime for employers if they do request an expedited hearing on a dolly citation for wage theft. No one, be they an individual or an employer, should be presumed guilty and have to prove themselves innocent for potential criminal penalties. I thank the committee for allowing me to testify and would be happy to answer any questions.
Thank you. Any questions for Mr. Hanson? Thank you for your testimony, Mr. Hanson. Next up, we have Lauren Schotthorst. Welcome to the committee. Welcome back to the committee. Please introduce yourself for the record.
Good morning, Mr. Chair, members of the committee. My name is Lauren Schotthorst, and I serve as the Labor and Management Policy Director for the Minnesota Chamber of Commerce. For those of you who don't know, the Minnesota Chamber represents 2,300 employers and over 500,000 employees in every industry across the state. The majority of our members are small and mid-sized businesses, and our membership does include many of Minnesota's Fortune 500 headquartered companies. I appreciate the opportunity to provide testimony and share the views of our members on this important issue. While we have concerns with the broad approach laid out in House File 6, as well as the author's amendment, we share the commitment to protecting employees from this crime. I'd like to first emphasize that the Chamber and its members do not support, condone, or approve of wage theft as a business practice. Our concerns make that this bill makes any failure to pay wages wage theft regardless of intent. A recent example we used is the Minnesota public school system implementing a new payroll system a few years ago, and its rollout, teachers and other school district employees reported missed paychecks, underpayments, overpayments, and thousands of dollars in unexplainable deductions from their checks. Our members are concerned that under a bill, even mistakes are now criminal. This is especially concerning for some of our smaller employees who may not have more sophisticated payroll software systems, if at all. An inadvertent mistake or error should not subject them to the serious penalties included in this amendment. Our members are concerned that the bill does not include reasonable good faith employer protections or due process provisions, and we are concerned that the bill overreaches in its application and enforcement by the onerous record-keeping requirements for employers and frequency of paycheck provisions that don't take into account the nuances of some Minnesota businesses whose cash flow or other business needs require a pay cycle of once per month. While we are proud that Minnesota employers are regularly recognized as providing some of the best workplaces in the nation, any action that reflects poorly upon our business community is something we take very seriously. We look forward to continuing working with you all in the legislative process to accomplish our shared goal of protecting employees from wage theft and hope to find a workable solution.
Thank you for your testimony, Ms. Schothorst. Any questions for Ms. Schothorst? Thank you for being here. We have Susan Siegel. And after Susan Siegel, I'm going to ask if there's anyone from the audience who wants to be heard on this bill. Welcome to the committee, Ms. Siegel.
Thank you very much, Mr. Chair. I'm Susan Siegel. I'm the city attorney for the city of Minneapolis. And just here to extend our support for this bill. Our prosecutors are ready, willing, and able to take on a new gross misdemeanor offense. And you have to make it more risky and costly to cheat for this very small percentage of employers who do that than it is to pay your employees the amount of money that they're entitled to. And this bill will help change that equation. As we heard from the building trades councils and others, it is a small group of employers, but they're the ones who prey on vulnerable people, the people who are patching together enough money to get by, particularly with our gig economy and other terms like that. In terms of criminal prosecution, the fear that I just heard, we have to prove things beyond a reasonable doubt. So an honest mistake, we are not going to prosecute that. It will never be brought to our attention. I would also advocate, I know it's going to Ways and Means next, but don't forget that the Department of Labor and Industry will need funding in order to enforce this new law, in order to be able to effectively enforce existing law, because they have not had the staff to do that, to do an effective job to enforce the laws we already have. And I thank you very much for your time.
Thank you very much for your testimony, Ms. Siegel. Any questions for Ms. Siegel? Thank you. Are there any, well, let's do this. Let's do your amendment, Representative Lucero. Your amendment is at the 810?
It is, Mr. Chair, and I move the 810 amendment.
Representative Lucero moves the 810 amendment. Go ahead.
Thank you, Mr. Chair. So as we're hearing from several of the testifiers that there are legitimate clerical errors that occur, and errors should not be, in my opinion, subjected or equivalent of intent to fraudulently pay employees or contractors. But if that is the case, and if that's what the bill author is intended to do, which he obviously is, this amendment makes it equivalent to both sides of the equation. That if there is a clerical error that is in favor or benefits and an employee or contractor is overpaid, that they would have an equal responsibility to notify the employer that they were overpaid in a timely fashion, and if they failed to do so, that they would be equivalent to the same penalties that are being placed upon the employer. So, Mr. Chair, I would hope that we can vote green on this amendment.
Any discussion?
Mr. Chair, there are plenty of penalties out there to punish employees that do just as this amendment talks about. I see no need for this amendment. I'd ask you to vote it down.
Chair Johnson.
Chair Lesh, I actually understand this amendment. why it's there. You can laugh, but employee theft is a very difficult thing to prove. I actually have a business that my family has. We had an employee, it took myself as a trained investigator with the sheriff's office, using my knowledge from investigation, took me 2 months of work to actually find out where the money was disappearing to. After that, we finally dismissed once we had enough proofs, we terminated the employee. That person took it to administrative law judge. 6 months later, we had our hearing, and the administrative law judge specifically said it was theft. We ended up taking it to have the local jurisdiction charge the person with theft with the information we had. 2.5 years later, and we found over close to $3,500, $4,000 in theft. It was dismissed because some of the witnesses that we had passed away. So we're looking total time, 3.5 years from the time we started seeing something wrong, to finding the information, to finding out who was doing it, to getting it to court. It's dismissed because of the system we have. Wage theft is an issue. I want to make sure we don't have any wage theft. But employee theft is an issue as well. We need to have both on equal grounds. We don't have that. And in this bill, when an employee steals, we have to show intent. In this bill with the amendment, there is no intent. You don't have to show intent to get charged with theft. Theft needs an intent. So if we're going to do it for one, we need to do it for both.
Mr.
Thank
Chair.
you.
I would just tell the
Go ahead, Mr.
representative
Mahoney.
to write up a bill. We'll take a look at it, and we'll try to put it together.
Well, I would state, I feel like knowing the Army pay system the way that I do, I know that when they overpay you, I was in Ranger School, broke my ribs, and they continued to pay me for 2 months after that, if I was back here. And you can bet your bottom dollar they got every dime of that back because I was still working for the Army, and they just took it out of every single paycheck thereafter. Employers are in a unique position. Oh, but if the Army owes you money, okay, because they underpay you, good luck getting that for like 3 or 4 years until you have to retired, okay? But I'm surprised there's no representatives of the Army here, because we're crying out loud. But I just think employers are in a unique position to get their money back if they've fronted money to you. And most folks on the 2-week pay system work for a month before they get their first paycheck, so there's plenty of notice on that too. Representative Lucero.
Thank you, Mr. Chair. And the argument that the bill author, Chair Mahoney, just gave as to vote against this amendment is that there are already laws on the books that employers or employees or employers could utilize to get money back. Well, that's true of current law. As we just heard from the testifiers, there are currently laws on the books that if intentionally depriving of fair wages that are due an employee or contractor, those could be the same. So again, that's not, in my opinion, a valid argument to vote against this amendment. So I would ask for a roll call, Mr. Chair.
Roll call has been asked for. Committee Legislative Assistant will take the roll. Chair votes no.
Representative Mueller?
No.
Representative Scott?
Yes.
Representative Barr?
Yes.
Representative Cantrell?
No.
Representative Carlson?
No.
Representative Considine?
No.
Representative Grossel? Representative Hassan?
No.
Representative Herr? Representative Johnson?
Yes.
Representative Liebling?
No.
Representative Lucero?
Yes.
Representative Noor?
No.
Representative O'Neill?
Yes.
Representative Robbins?
Yes.
Representative Zhang?
No.
The amendment fails on a 9-6 vote. The amendment is not adopted. Anyone from the audience who is here and wants to be heard on House File 6 as amended? Seeing none, any other committee discussion on the bill? Representative Barr.
Thank you, Mr. Chair. Representative Mahoney, as I'm looking through the bill, everything says employee, employer, and one of your testifiers is a subcontractor, so I was wondering how this applies to subs, and also I noticed also with, it's kind of in conjunction with what Chair Considine had brought up with the, if there's a bankruptcy or something like that, does this reorder wages ahead of secured lien holders or anything like that so that wages are paid first? So the two questions, please.
Thank you, Mr. Chair and Representative Barr. I wish I could change the bankruptcy laws to that, but this bill does not do that. The subcontractor, the value from this particular bill as a subcontractor is that subcontractor will be on a fair footing bidding for a job, whether it's you're bidding to drive a truck or you're bidding to put up sheet wall or rafters. You don't have someone saying they're paying someone $20 an hour and they're really paying $10 an hour, or not paying their Social Security or paying income tax in. So the contractors get a fair shake to take a shot at a good contract. Bankruptcy, no, this bill does not address bankruptcies.
Representative Barr. Representative Considine.
Thank you, Mr. Chair. I want to apologize to Representative Johnson. It was just the way you phrased it, and I apologize for laughing.
Thank you. Any other comments from the committee? Representative Lucero.
Thank you, Mr. Chair. And I just want to reiterate one of the hypotheticals that one of the testifiers gave about an employer paying an employee two different salaries. So some may know that I drove a truck for nearly 6 years as a Teamster truck driver. Great time. But part of that, I also was a wedding cake deliverer, because at the time, McGlynn's Bakery did wedding cakes as well. And so I got paid a different wage when I was on the clock delivering wedding cakes. And I might save some of those very interesting stories for the House floor. But
I hope you didn't jump out of a cake.
I can only wait.
There was much room for human unintentional error in paying me, calculating the hours worked when driving the truck versus delivering cakes. And I am just incredibly concerned with the bill having the lack of intent being there, and with much margin for error. It is a real concern that an employer can make a genuine mistake. And for an employer to make a genuine mistake without intent, for them to be held liable to this extent is, again, very concerning. Additionally, there are many employers, as the tax code continues to have many shifts that are occurring, and in the state of Minnesota, for example, we haven't conformed yet. Employers need to perform upgrades to software, and many employers, I know small businesses, they've outsourced to different ADP, for example, and other payroll-type vendors, and a software code could inadvertently deprive somebody of a salary that they're due, or a wage that they're due. And again, intent was not part of the equation of depriving them. And again, with these concerns, they're real, and I would just urge members to vote against this bill. Thank you.
Thank you, Representative Lucero. Representative O'Neill.
Thank you, Mr. Chair. So, I used to own a subcontracting business. We did tile setting. Maybe you didn't know that. So my son is still a tile setter. My ex-husband owns the business with another business partner. And I appreciate the testimony, particularly that talked about the fact that this is an unequal playing field. And we saw that all the time. The bid is your life. If you overbid, you have no life. You have no jobs. So I really do appreciate that. And of course, none of us at this table want wage theft to happen. That's a non-starter. We don't want that. I do have, I'm going to go into the words, but just a couple questions. I had already mentioned to you, and this is in the original bill, not the amendment, but the specific format, if you want to look at that a little bit closer. Also on page 3, and it was brought out in the testimony again too, line 3.5 through 3.7. I'd really encourage you to think about this just a little bit more because it's really onerous for some people in some situations. Lots of people have home businesses or, home offices, I should say. Just as someone testified, they could be, the employees just go to the job site, and the office is actually at someone's house. But even more so, say like a convenience store that maybe has a really small footprint, they might have the majority of their paperwork at the home as opposed to at the store. So if you would just think about that a little bit more, there's a lot of situations where I don't think this wording is going to work very well, and it's kind of confusing to those that own businesses. So I'd encourage you just to work on that a little bit more. I think a couple people in the testimony said that as well, that it's a little bit confusing. And if you want businesses to comply, it needs to be clear, which is why I brought out, the part about the specific format, when really it's asking about specific content, which is a completely different thing. So those are my only two comments. Of course, I'm supportive of, making sure we don't have wage theft, and especially being an owner of a business not too long ago that it affected us tremendously. The margins are not that great, and we actually started our business in the throes of the Great Depression that we had, where we had foreclosures everywhere, and the housing market crashed, and the construction market crashed. So I know what that feels like to go, as a family, to go through that pain. I think we saw about a 30 or 40% reduction in our household income during that time, and that's when things got really, really, really competitive. So I appreciate this, and I understand what you're trying to do, but there's just a couple things I think that still need further work. So if you would take a look at that.
Representative Cantrell.
Thank you, Mr. Chair, and I want to thank Representative Mahoney for bringing this bill. I think it's extremely important. And I do want to just bring the committee's attention to the amended language in the 813 amendment that was adopted on line 11.30 that adds the intent language to this statute. And Mr. Chair, I'd like to request a roll call, please.
Roll call has been asked for. Representative Johnson.
Mr. Chair, Representative Mahoney, one thing that we haven't really talked about is the subpoena power given the commissioner. I'm a little concerned with that, as it can so easy to be abused. We're seeing some of that elsewhere where subpoena power is used for reasons sometimes can be a witch hunt, trying to find something that's wrong. If you're going to have the subpoena power, I wish you'd get some guidelines in that to make sure that there's a legitimate reason for that.
Certainly can look at
Thank
that.
you. Any closing comments, Representative Mahoney?
Mr. Chair, thank you for the time today. This is a good bill. It gives a lot of ability for the department to deal with wage theft as an administrative problem and administrative penalties versus going into the criminal world. I don't want, and in this bill specifically, time and time again, let me grab the language. In determining the amount of a civil penalty under this subsection, the awareness of such penalty to the size of the employer's business and the gravity of the violation shall be considered is throughout. I don't think anyone wants a small business to go out of business. We have addressed all of the questions. I'll sit down and show you where they are. This bill is a bill that will help people, as the commissioner said, live the good life of America that America has to offer. And it will get them the money that they have worked hard to get. Thank you, Mr. Chair, and see you on the floor, I hope.
Thank you.
Got to go to my committee.
Thank you, Representative Mahoney. Chair's motion is that this be re-referred to Ways and Means. Roll call's been requested.
As amended?
As amended. Chair votes aye.
Representative Mueller?
Yes.
Representative Scott? No. Representative Barr?
Yes.
Representative Cantrell?
Yes.
Representative Carlson? Yes. Representative Considine?
Yes.
Representative Hassan?
Yes.
Representative Johnson? No. Representative Liebling?
Yes.
Representative Lucero?
No.
Representative Noor?
Yes.
Representative O'Neill?
Yes.
Representative Robbins?
No.
Representative Zhang,
Yes.
On a vote of 10 to 5, the motion does prevail. You're on your way. Thank you, Representative
Mr.
Mahoney.
Chair, thank you, committee members.
Next bill up is House File 554. Thank you for your patience, Representative Moran. Got to sit through an hour of wage theft.
You're going to claim more money.
Representative Moran's bill is 554, and the chair moves that House File 554 be recommended to be placed on the general register. Welcome, committee, Representative Moran.
Good morning, Mr. Chair.
One moment, Representative Moran. I know you're excited, you got your bill passed, but if you can please take your conversations out into the hallway, we have more business in front of us. Please proceed, Representative Moran.
Mr. Chair and members, House File 554 has two main objectives. First, it allows parents to petition directly for restored custody. Second, it provides that expunged records can no longer be allowed to be disqualifying factors on background studies when determining certain licensures from DHS. So I would just like to make it really clear that this bill only affects cases in which parental rights were terminated for non-egregious harm. We're not talking about situations where there were documented physical, sexual, or psychological abuse. We're talking about cases in which a parent had perhaps a chemical dependency or a mental illness which fortunately led to their parental rights being terminated because they couldn't get the help or treatment they needed in time. And I'm trying to cut my opening statement down some for
The
the sake
committee
of my
always appreciates
testifier.
that. Chair Moran.
So the bill also modifies procedures already in the law relating to the reestablishment of parental rights. So it allows for the parent to file petition seeking the reestablishment of parental rights. It removes the age requirement on children in foster care who have not been adopted, and it decreases the length of time from 36 to 24 months that has elapsed since final order terminating the parental rights. So why is this good policy? When children are in foster care and there has not been any permanency presented and their parents have been rehabilitated, returning to a safe home is in their best interest. This bill requires parents who are petitioning for this relief to prove that they have corrected the conditions that led to termination, and it provides a unique statutory opportunity for parents who've been rehabilitated. So this will help children return to a safe permanent home, and there is still significant opportunities for the counties and ultimately the court's discretion and approval for a petition after the hearing in court. I would like to stop there, Mr. Chair, and allow my testifier to present her testimony.
Thank you. Welcome to the committee. Please introduce yourself for the record.
Nice to see you. Hello, committee members. My name is Joanna Woolman, and I'm a professor and the director of the Institute for Children, Families, and Communities at Mitchell-Hamlin School of Law. I have worked as a representative of parents, a parent attorney for more than 15 years, including a clinic we currently run through our institute. I'm very happy to be here today to support this bill, and specifically I will be discussing the change in process that allows a parent to petition for the right to reinstate their parental rights. In 2018, there were 1,725 children in Minnesota under state guardianship. That means that they are basically in foster care limbo. They have not been adopted, and their parental rights have been terminated. 30% of these children were aged 6 to 11, 29% were under 6 years of age, and 39% were between the ages of 12 and 18. 63% of these children were children of color. I'm here today to speak about why this bill is important. When a child is in foster care limbo and has an opportunity to go back to a parent who has been rehabilitated, that is absolutely in that child's best interest. We know the long-term impact and outcomes for children who age out of foster care. Across the board, those outcomes are worse. High school graduation rates, contact with the criminal justice system, Mental health and chemical dependency issues and teenage pregnancy are all things that we know are more likely to occur when children age out of foster care. In its current form, this bill has never been utilized in Minnesota. My understanding is that it is never, a county, which is what the current bill states, a county attorney or a county has never brought a petition for the reestablishment of parental rights. So this is essentially a bill that has never been implemented and is non-actionable at this point. To give this bill some context, there is still going to be a ton of discretion over whether or not this can happen. A parent will need to prove that they have been rehabilitated. And the county and guardian ad litem are certainly going to be able to weigh in and provide their input as to what's in the best interest of the child. This gives children an opportunity to return to safe homes. That is in their best interest. I would be happy to answer any questions. Thank you.
Thank you for your testimony, Ms. Woolman. Any questions from Ms. Woolman? Thank you. Your next testifier, is that Mr. Elwood? Welcome back to the committee, Mr. Elwood. Please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair and members. Ron Elwood with Legal Aid. We are very happy to be here in support of House File 554. The statute that is being amended was actually a proposal that Legal Aid brought several years ago as a result of cases that we have had that in our youth law project of, for example, some teen parents who, when they gave birth, were simply not capable of taking care of the child, and 10 years later, these are citizens who have started their families, you know, and are now capable of doing it. And I just want to make a couple of points. Several states have laws of this nature. There are not a lot of cases in these states that come forward every year, but the ones that do, and for the people for whom this is intended, it's an incredibly meaningful and compelling right that they will now have, and the ability to reestablish that parent-child relationship. And finally, I'd just like to point out that this is a high bar. It's clear and convincing evidence, evidentiary standard. That's high. And I think purposely so, because what it does is it balances the second chance principle that I think we all want to give people with the other side of the coin, which is ensuring protection of children and the public safety. So thank you, Representative Moran, for bringing this forward and making the proposal that we first put in law actually work for the people it's intended to. Thank you very much.
Thank you for your testimony, Mr. Elwood. Jonathan McClellan? Welcome to the committee. Please introduce yourself for the record and begin your testimony.
Mr. Chair, members, hello, my name is Jonathan McClellan, and I'm speaking on behalf of the expungement portion of the bill. I'd like to thank this committee for giving me an opportunity to share with you today. I would like to thank Representative Rena Moran for carrying this important piece of legislation. In 2008, the Collateral Sanctions Report was issued to the legislature. This was the product of the Collateral Sanctions Committee created and fully funded by the Minnesota legislature in 2007. In that report, it stated that the legislature should carefully restrict the number of convictions that will trigger absolute bars from particular kinds of employment or eliminate such bars entirely. The committee received compelling accounts of people who were unmistakably rehabilitated, who gained valuable insight from their experience, and who cannot use that understanding constructively because they are absolutely barred from working with the people whom they could do the most good. This report goes on to state that exceptions should be made for exceptional people, and those who have obviously turned away from wrongdoing ought to be able to put their crimes behind them. In 1974, the Minnesota legislature declared that it is the policy of the state of Minnesota to encourage and contribute to the rehabilitation of criminal offenders and to the system and the resumption of responsibilities of citizenship, the opportunity to secure employment or to pursue, practice, or engage in a meaningful and profitable trade, occupation, vocation, profession, or business is essential to the rehabilitation and resumption of the responsibilities of citizenship. This report indicated that 3 decades later, now 4, we have experience the difficulties of setting rehabilitation as a goal for policy. The question becomes, how does this impact our communities? Here's how it has impacted my life. In the mid-1990s, I was a young homeless high school student in Ramsey County who pled guilty to a crime that permanently barred me from working in the healthcare field. I found this out after I successfully completed the EMT program at Hennepin Technical College. The final part of the program required me to pass a background check so that I could do my clinicals. I was informed at that time that I would be removed from the program because I was unable to clear a background check from DHS. I convinced the director at the school to keep me in the program until the situation was resolved. I went to the licensing authority called the EMSRB board who regulates EMTs, and I was told to fill out an application for consideration and fill out an application for a background study. I then had to submit to a background check with the EMSRB, and a hearing was scheduled for me to present my case. I was called back into the hearing, and after a unanimous vote, I was granted permission to proceed. The EMSRB found an ambulance service that was not affiliated with a hospital requiring licensing by DHS to do my clinicals and finish my requirement for school. I successfully finished my coursework and clinicals, and my license was granted. As part of maintaining my license, I had to be working in the EMS field. I got a job working for Cart Ambulance, which involved transferring patients between hospitals. After I was hired with Cart Ambulance, 3 days later, I was told that I did not pass my background check and I was going to be let go. I pleaded for my job back and was told that the ambulance services hands were tied and I could no longer work there, but if something changed, I would be allowed to return. At this time, I applied for an expungement with the court, and the expungement was granted by the Chief Judge of Ramsey County. I then found an ambulance service in Belle Plaine not affiliated with a hospital that would allow me to volunteer. The ambulance service was taken over by Alina, and we were told that we would have to apply and go through the hiring process again. Around this time, the Minneapolis Fire Department was hiring, and I submitted an application. Out of close to 3,800 applicants, my final ranking was number 24 based on my test results. The personnel chief of the fire department called me and informed me that I had to write a letter explaining what was on my background check and it would need to be reviewed and approved. The Minneapolis Fire Department eventually got back to me and let me know that I would be able to continue the process. The process consisted of medical testing, college, fire academy, and intensive psychological evaluation. I would eventually earn the coveted title of firefighter. Several years after I was hired, the state passed a law requiring all firefighters to be licensed. In order to be licensed, I would have to submit to another background check and do a Q&A by the board as to my background. My application again was unanimously approved by the firefighter board, and I was granted my firefighter license. A few years after this, I was injured in the line of duty, saving a young man's life, and I was not able to return to the work I loved because of my injuries. Despite having thousands of successful patient contacts, I wanted to go back to the root of this issue and fight for people who are similarly situated. As a family man with 4 kids ages 7 to 19 years old, I have tried to teach them the importance of fighting for what they believe. For almost 15 years, I have worked to change this policy. I am passionate about meaningful criminal justice reform in our state and operate behind the scenes where policy is crafted. I have served on the Human Rights Commission for both Bloomington and Richfield. I have also served on the District Diversity Advisory Council for the Bloomington Public School District. I have also ran for public office. I've graduated from honors from community college in business with continued studies in fire science, hazmat, arson investigations, legal writing and research. And I graduated with my BA from Metropolitan State University, magna cum laude, with a focus on community leadership, management, and pre-law. I will continue to do my part as an engaged citizen to make sure the scales are balanced on social issues and reforms that impact families and marginalized communities. Thank you.
Thank you very much for your testimony, Mr. McClellan. Thanks for taking the time to be up here. I will never forget the first time I, as a young prosecutor, had a person who was in a bar fight up at, was that used to be called Lions on Grand or something, Lions Tap, something. And she was in my courtroom for a 5th-degree assault. And she said, listen, yeah, I hit someone in the bar. I was drunk. I got to get down to class. I'll plead this thing right away. She wanted to take cop a plea to 5th-degree assault. And I said, out of curiosity, where are you going to school? St. Catherine's. I said, yeah, what are you majoring in? And she said, nursing. And I said, oh, you just want to take a plea to the 5th-degree assault, huh? And she said, yeah, I need to get down to class. And I said, no, you do not. how much debt do you have? And she said, $80,000. And I said, well, it's an $80,000 day for you if you, and probably more because she'd go on school for another year and pay more before she found out she wouldn't give me a nurse. And people like that, and you have to fight so hard just to have to undo these things. And you're an asset to our society and your community, and we thank you for fighting hard for us, and now we want to fight for you and folks like you a little bit, so thank you.
Thank you.
Representative Noor.
Thank you, Mr. Chair. Thank you so much, Representative Moran, for carrying this bill. I've got a question for Mr. McClellan. If this bill moves forward, will that assure that DHS will not disqualify individual based on the expunged record?
Mr. McClellan.
It's my understanding that there's questions to that fact, and I don't know that question for sure.
I think we may have someone from DHS.
Mr. Moran.
who can
I mean,
respond to that.
my understanding is that the commissioner still has waiver opportunity, but let's get the clarification on that. I think the answer you're looking for is no. They still can if they want to, right? But go ahead. Please introduce yourself for the record and answer Representative Noor's question.
Mr. Chair, Committee, Patrick Carter from DHS Office of Inspector General. Representative Noor, to answer your question, our interpretation of the changes being made in this bill do not amend the impact of expungements on DHS background studies. It kind of reinforces the authority that is already in place in terms of expungements, but it doesn't expand it in any way.
Thank you. Representative Noor.
Mr. Chair, does this bill mean that whatever we're putting into the law right now will become mute? It's not going to become effective in addressing the situation that Mr. McClellan just addressed the body?
Mr. Chair, Representative Noor, our understanding of the language here is that it would not address Mr. McClellan's situation or others in similar situations.
Representative Noor. Yeah, I mean, there are other folks I think who are going to testify in this, so they may have answers for that too. But if you want a clarifying question, go ahead.
So how do we amend this bill to make sure that we address those issues that we've just talked about? You know, if something is expunged, that we either trust the court system or we don't. So the question is, how do we provide a situation whereby somebody who's rehabilitated, somebody who is in the community can do a direct care work, as long as they're not threat, they don't show any evidence that they'll create any harm to any person. How do we make sure that the bill reflects the intent of this, the intent of the bill itself?
Mr. Chair, Representative Noor, there are, I think, two approaches that could achieve that aim. The first would be to expand the list of crimes that are eligible for expungement for DHS's purposes. So amending 609A.03 and expanding the list of crimes that are eligible for expungement. The second would be to amend DHS background study statutes 245C15, where there is currently a prohibition on the commissioner setting aside permanent disqualifications. Both of those kind of address that rehabilitation issue that I think you're asking about. But from our understanding of the author's intent and Mr. McClellan's intent, that those would be one of those would need to be the changes made.
Thank you.
Thank you, Mr. Chair.
Any other questions from members of the committee? Okay, yeah, Chair Scott.
Thank you. Real quickly, and it might be in the bill, and I'm just not seeing it. It might be current law. Is there any follow-up after this reunification happens to check in on progress and see how things are going?
Chair Moran.
Mr. Chair, Representative Scott, I don't believe there is any follow-up once reunification has taken place, which is based on final approval from the court.
Thank you. Okay, we have other testifiers which should be heard on this bill. Please come on up, introduce yourself for the record, and begin your testimony.
Good morning, Mr. Chair, members of the committee. My name is Janet Reiter, R-E-I-T-E-R. I'm the Chisago County Attorney, and I'm here in my capacity as the chair of the Minnesota County Attorneys Association Juvenile Law Committee. The Minnesota County Attorneys Association Juvenile Law Committee has been involved and has reviewed the proposed legislation for the reunification or reestablishment of parent-child relationships as set forth in House File 554. We've had multiple discussions, and we've actually had the opportunity to meet with the author and have some fruitful discussions there as well. We hope to continue to be at the table as this bill moves forward through the process. However, we do have some concerns that we'd like to draw the committee's attention to. The MCAA, who represents local social service agencies in these actions, would like to have included in this bill a notice requirement that would require a petitioning parent to provide notice to the local social service agency 90 days or possibly 60 or at least 30 days in advance of filing a petition to reestablish the parent-child relationship. What we know is that these children who are in foster care for various reasons as a result of the termination of parental rights, why they remain in wards of the state could be a variety of reasons, and we know that oftentimes the children may be struggling with mental health issues of their own. The goal of the MCAA and local social service agencies would be for this, if it moves forward, to be in a most planful process that would keep the best interests of the children at the forefront of the process. So as we see in the bill, in order to initiate this process, a parent who's bringing forward a petition would have to file or serve the child. And so we think that it would be appropriate that the local social service agency would have notice of this, would be able to prepare the child, and make this a planful process and truly in the best interest of the children. Also, the MCAA thinks, or would like to see a provision in here that would provide some restrictions on the number of times that a parent may be able to come forward with a petition to reestablish parent-child relationships. If they file a petition, come forward, and the matter is litigated, and it is the decision of the court that reestablishment of that parent-child relationship is not in the best interest of the child, we would like to see some restriction that would limit or at least delay that moving parent to come back before the court for another bite of the apple, so to speak. This would allow there to be some stability. It would reduce the amount of frivolous or unneeded litigation in this area, and it would just provide more, a better use of the limited resources in both our local social service agencies and in our courts. The final point that the MCAA thinks is important is the elimination of the age of the child to which this bill would apply. Currently, the law requires a child to be 15 years of age or older. MCAA has looked at this and discussed this, and it's our position that an age where the child might be old enough to advocate for themselves, weigh in, have access to counsel would be appropriate age limit on this. So while currently it's 18 or 15 years of age, the bill would eliminate that age requirement in its entirety. We would be proposing something in the nature of 14 years of age, which is the age at which a child currently has the right to consent to an adoption. So it's already an age that's built into our laws for them to weigh in on their future. Or 10 years of age. For a parent to petition to reunify or reestablish that parent-child relationship, we think 10 years of age would be appropriate because that's the age at which the court would assign counsel to represent the child in these proceedings. We think it's very important that, again, that the child's best interests be kept at the forefront of these proceedings and be the focus at all steps of the process. Thank you.
Thank you, Ms. Ryder. Questions for Ms. Ryder? Chair Liebling.
Thank you, Madam Chair, and thank you very much for your testimony. It does raise some questions for me. First of all, I'm very glad that you're talking about the best interests of the child, and I'm sure that Representative Moran agrees that the best interest of the child is the real interest here. And we've learned a lot. I've learned a lot recently from Representative Moran's work about, how critical attachment is for kids and how devastating it is for kids to be separated from their parents in the first place. That's kind of an aside. But my question for you, one of your concerns is about more bites of the apple than one. And I just would want to direct your attention to line 3.14 and through 3.16 of the bill, and it talks about the parent has to pay a filing fee, and it refers to another section about how much that is. And I'm wondering if you know how much that is, because I would think that having to pay to file is a deterrent from filing successive petitions. So could you address that?
Ms. Wright.
Thank you, Mr. Chair, Representative Liebling. Off the top of my head, I'm not certain about the amount of the filing fee, but it is well over $100, and so that might be a deterrent for families. However, it also may be waived if there's evidence of indigency where they could proceed in form of pauperous, where they are representing to the court that they do not have the sufficient funds. So while there is a fee that would still attach to this filing, it oftentimes, I presume, may be waived by the courts.
So, Mr. Chair.
Chair Liebling.
Thank you, Mr. Chair. And so, you may be right that they could get it waived and so on, but I have to say, most people don't really like coming to court, don't like having courts examining their business. I think, given the testimony that we've heard about nobody using it under its current form, I'm kind of surprised that there's this more bites of the apple concern. I mean, if that happened, surely we could come back and do something to restrict it. But I think the concern here is that it's not even being used when it perhaps should be used. And there is a hurdle here, and it is A, a filing fee, or B, having to go through this rigmarole in the first place, which many people probably won't even. I mean, let's face it, people are intimidated by courts. We all are, even those of us who are lawyers. We don't want to have to be there if we don't have to be there. Your other concern about notice to a social service agency, I mean, that does seem reasonable to me, and I don't know if there's opportunity to work on the bill further, but I do think that there is something there that we should perhaps consider, and I don't know if Representative Moran has already thought about that. I guess I'd like to hear what she has to say about it.
Chair Moran.
So, Mr. Chair, Representative Liebling, I really don't have any problem with the petition of the parents for the 30-day in advance notification. I think that's reasonable, and don't really have a problem with the number of times a parent can petition. Knowing that a parent may be in a position who have went through all the hurdles that he or she may have needed to go through to file the petition, including hire her own attorney, him or her own attorney. And I think it would be like at the end of, I can't quite remember, at the end of that first process, at the end of it, it'd be like another year before they can petition again. And I'm more than willing to work with the county attorneys as the bill moves through the body. My only concern would be with the age limit. I mean, it's an arbitrary number that means like really nothing. Let's say we have right now 32% of our kids are in out-of-home placement between the age of 6 and 11. And let's say a child was taken out their home at 7. And they've been sitting in the court system for 2 years. They haven't been adopted. They're in out-of-home placement. And the parent within that time has reestablished themselves. They're doing well in the community. And they're at the point to say that I believe I have a good, stable, safe, nurturing environment for my child, and I want to petition the court. And so that's 2 years later. Now that 7-year-old is now 9 years old. Why should that individual need to wait another year, another 4 years, or 5 years before that parent can petition to have her child reunified with her in her home? And so we can continue to work on it. I'm very open to the first two. I think we have to work on whether or not a number is really important to really create a nurturing, safe environment for a child to be reestablished with a parent, with their family, it's important.
Thank you.
Again, Mr. Chair.
Chair Liebling.
Thank you. Just quickly, staff gave me the number. It's $285. That's a lot of money to file. So I just really, some of the concerns you've expressed, I think, are very valid. I'm really glad to hear that you'll work, and that's great. But I don't know, the successive bites of the apple thing kind of doesn't resonate with me, especially given that amount of money.
Thank you. Thank you for your comments, Ms. Ryder. Anyone else from the audience who wishes? Oh, Representative Mueller. you have a question for Ms. Ryder?
I actually did, yeah. Thank you,
Okay,
Mr.
come on
Chair.
up, Ms.
And
Ryder. Go ahead,
Chair
Ms. Moran.
Moran, I'm really glad to hear you're willing to work on those two things. I handle appeals, and we get a lot of second bites at the apple folks that come filing successive petitions. So I actually do see that, and I know there's the waiver here for the indigent party. So that is a little bit of a concern to me, and so I guess I'm glad you're willing to talk about maybe putting some structures around that. But my question has to do with appeals. If somebody is denied under this process, do they have the right then to appeal from that? If you know
Ms.
the
Ryder.
Thank you, Mr. Chair, Representative Moeller. Currently, that would fall under the Rules of Juvenile Protection Procedure. I don't know that the rules specifically would address this. We anticipate that if a district court denied an application or a petition to reestablish parent-child relationships, that if it were deemed to be a final order, that it could be ripe for an appeal under the current Rules of Juvenile Protection Procedure. There are a number of other points within the juvenile court process that it is determined to be a final order, an appeal may be brought. So to be honest, I would, at this point, I would assume that it would fall within those rules.
Yeah, Mr. Chair, thank you. And that's what I was thinking too, that a person would have that other option to have an appeal, but then also given the timelines for appeal process by putting timeline limits on the number of successive petitions, because things might actually be moving through the appellate courts at the same time. I think that makes some sense. So anyway, thank you.
Thank you very much. Any other comments from anyone else? Oh, Representative Robbins.
Thank you, Mr. Chair, and thank you, Representative Moran. I had a question about 3.20, where it says that the clause, it says the responsible social service agencies and the county attorney agree that the reestablishment of legal and parent-child relationship is in the child's best interest. We've spoken a lot about this needing to be in the child's best interest. But then it says this clause must be satisfied only when the county attorney is the petitioning party. So when the parent is the petitioning party, that doesn't need to be the governing, the child's best interest does not need to be considered. I'm not understanding why, if you could just elaborate why it says that clause must only be satisfied when the petitioner is the attorney.
Chair Moran.
Thank you, Mr. Chair. So to be very clear, this is always about in the best interest of the child. But when a parent bring a petition for reestablishment of parental rights and go through the court system, it doesn't have to get the approval from the county attorney or the social service agency. It is really up to the parent and the court. And the judge will make that decision.
Representative Robbins.
Thank you, Madam Chair. Well, I do think that's a little bit still confusing why it says this clause about the child's best interest must only be satisfied. So maybe that's something you could think about. And then I would also just like to say that I share the concerns about the age limit. I have had family friends go through a situation like this where the child under the age of 15 was getting extreme pressure from a parent. And I think that puts a child in a very difficult position. They want to be responsive to their parent and please their parent, but maybe it wasn't still in their best interest. And I think children are very vulnerable to pressure from their parents. So I just think having the age limit at some level where it's 14 or 15 or 10, but some structure around that is helpful to protecting children's best interests. Thank you.
Moran.
Well, I disagree that, and I do understand that situation for that individual and that parent, but we do know every situation is different. And I think we need to look at it through that lens, that every child is different, every family is different, every circumstances is different, and then rule accordingly, according to that. What we do know is that often kids are lingering in the system way too long, and that impacts, the trauma that they're going through. Sometimes it impacts their development. It enhances the mental illness that we find themselves. It's a pathway to the criminal justice system. And I think what we want is that we do want kids to be in a safe, thriving, nurturing environment. And that environment could be the home of their mother, of their father. And so we just need to create that pathway because right now that pathway is not available unless you are 15.
Chair's motion is that House File 554 be recommended to be placed on the general register. All in favor signify by saying aye. Aye. All opposed say no. Motion passes.
Thank you,
you
Mr.
very much.
Chair.
You're on your way, Representative Moran. Tonight in the basement hearing room at 5 o'clock, we'll be taking up both of Chair Scott's bills. We'll take up the little one first. The little one. Yeah, with many amendments. So there being no, committee is in recess.